All right, good afternoon, everybody. Welcome to the current edition of the monthly Hicks Thomas CLE series. Today's series is going to be called What I Learned in Trial. It's going to be a panel discussion. We're going to talk about the good and the bad and the ugly of being a green attorney and having your first trial, and what the experience is like from the perspective of a more senior attorney who's trying a case with a green attorney. So next, I'm going to introduce our panelists. First, we have Miranda Granchi. Miranda, if you could wave so the camera sees you.
I'll just try to talk.
Okay. Miranda clerked in the Southern District of Texas. She's also a graduate of the South Texas College of Law, where she was on the law review and the senior articles editor. Next, we have Liz Larson.
Hello.
Liz clerked for a Harris County District Judge. She also clerked in the Northern District of Texas. Not only that, but she was also the interim general counsel of a nonprofit. She's been selected as one of the best lawyers ones to watch. She's also a graduate of Penn Law School. And last but not least, we have Stephen Loftin, a founding member of Hicks Thomas.
Hello, everyone.
He's a life fellow of the Houston Bar Association and the Texas Bar Association. Not only that, but he's a member of the American Board of Trial Advocates and a recipient of numerous other awards, in addition to being a fantastic mentor to younger attorneys. So next, let's turn to some of our themes we're going to work on today. Most of this will be from the perspective of a first trial experience. We're going to talk about direct roles and also indirect roles that young attorneys might have in their first trial. And as I alluded to previously, we're also going to talk a little bit, Stephen will give us valuable perspective on this, about what it's like to be a lead attorney and working with a green, so to speak, attorney. Also, we're going to talk a little bit about the advantages and weaknesses that younger attorneys can bring to the table and how they can mitigate those weaknesses. Before we get started, everyone, why don't we go around and if everyone could just give an overarching piece of advice for someone who's a young attorney trying the first case.
I think I would start out by saying to be yourself in the way you approach a trial. I think your fact finder, whether it be a judge or a jury, can see through you trying to use techniques that maybe don't work with your personality as well. I like to approach it by kind of knowing your character trope, right? Are you the cowboy? Are you the bully? Are you the professor? Are you the counselor? How best can you approach a fact finder in an authentic way?
I'll take it from the senior lawyer's perspective, which is you need to just let go. It's often hard for a senior lawyer, particular trial lawyer, to let go and let go of your control, let somebody else take over parts of the trial. It's easy to want to do it all yourself. So you need to be comfortable just letting go and letting somebody else take part of the trial. And with that, you need to recognize that, like most trials, not everything goes as planned. And you'll probably add to that a little bit when you're having a younger lawyer that may never have been to trial before. You can expect that things won't go as planned, but it's always inevitably something you can overcome. And the bottom line is that it's well worth it to have these young lawyers come in and get some experience with you. So just be prepared for the unexpected. Yeah.
Apologies, folks. I think we just figured out our fancy camera is not panning to the speakers as it was supposed to. If you'll just give us one quick second, hopefully we can get that fixed. All right,
There you
sorry,
go.
sorry about that, folks.
Another example of things not going as planned.
Yes, always be prepared for your technology to fail.
That's right. So let's reintroduce ourselves one more time. I'm Ryan Cordell.
I'm Liz Larson.
I'm Miranda Granchi.
And Stephen Loftin.
All right. So moving on, why don't we talk a little bit about pretrial? So some things we want to talk about in pretrial, the jury charge, exhibits, presentation of exhibits, and also motions in limine. In my experience, pretrial is often something that younger attorneys get involved in for their first trial. So I'll throw this one to the team. Why don't you tell us what the young attorney needs to know about pretrial?
Yeah, I'll start from a senior lawyer's perspective. As you mentioned, Ryan, one of the things that a young lawyer can do often in a trial, getting ready for trial, is to help with the exhibits. And it's not really until you've gone through a trial, whether you're observing it or actively involved in it, that you appreciate sort of the end result of why it's important to go through these things with the admissibility of evidence. And so the young lawyers need to know it's more than just putting exhibits on a list and using all the documents that were discussed in the deposition and have them on an exhibit list. You have to go through the mental effort of trying to figure out how in the world that stuff's going to walk into evidence, and what witnesses or what questions do you need to ask in order to be sure that you'll have that ready to go, because they don't always walk in on.
And I think it's important to know, there's gonna be a bomb, right? Like, you may get that motion in limine saying it's not gonna come in, but that doesn't mean it's not gonna come in. And if it does come in, what are you gonna do about it? Opposing counsel is going to send you an amended exhibit list 12:05 PM before the morning of trial. Make sure you know how to keep track of what the changes are and how you're gonna adjust to those.
What about differences in preparing and introducing exhibits in state and federal court?
Well, my experience is that in federal court, it's usually going to be worked out beforehand, but not always. We're involved in a trial recently in federal court where we spent 2 days in pretrial and still didn't get through all the exhibits. And so it was an issue. We'll talk about this later on with opening statements and the use of documents. And so in state court, it's rare in my experience that you have that kind of pretrial where they spend the time and have the patience to go through it all. So in federal court, you just need to spend more time preparing the arguments and how you're going to get the evidence in or prevent it from coming in, because you're going to have to deal with that with the federal judge before trial in most cases. And for state court, you're just going to have to be ready to wing it during trial, but you need to have those same issues spotted beforehand.
So let's say you get your exhibit in. Let's talk a little bit about publishing it to the jury. How exactly are you going to do that, and what type of preparation might go into successfully putting on your exhibits?
Anyone? I can tell you again, it depends on where you're trying the case. It's not just state or federal, but it may be the location. If you're in a rural county or in Harris County, because not all the technology is there, but it doesn't always work. And so one of the key things that often a young lawyer will be charged with is getting over to the courthouse before trial to look at the setup, to figure out what the equipment is, what's going to work. Do you have an Elmo? Are you going to have to use that? Or are you going to use computers? And are the computers going to work with the court system? What we learned recently, Miranda will remember that our consultant who was doing our exhibits for us was an Apple person, and the federal courthouse don't speak Apple. And so it was an issue initially in the trial. She had to run out literally the day before trial by a different computer and then redo all of her work the night before trial.
Well, and in that kind of first trial bucket, have a thumb drive with all the exhibits, a clean copy and your highlighted copy, because someone will have a computer, someone will have something that will work, but you need to make sure you have a way to use it when you get that opportunity.
And paper copies.
And paper.
Because, I've seen trials when I was clerking where no one's technology was working and was on the fritz, and we had to scrounge up, we'd use court copies, to have paper copies, and it's not really good look in front of the jury if you spend 10 minutes trying to just get an exhibit up and you lose the flow of your questioning, and it doesn't ever look good. You look unprofessional and unpolished.
Yeah.
if that's the
And
situation.
If it is a
Mhm.
really big exhibit, obviously, you can go the demonstrative route, have it blown up, because, a giant piece of cardboard will always work in
Mhm.
any courtroom.
Yeah, I think the theme there is to, as the young lawyer, you may be charged with getting with the court staff, figuring out what's available and going over and making sure things work, but be prepared for the worst, and redundancy is important.
Absolutely. And to add on to those 2 points, getting the chance to go over to the courthouse and look at the technology allows you to introduce yourself to the court staff and get familiar with what otherwise might be a unfamiliar environment. The other thing is, as to the exhibits, if you have everything on the thumb drive, when the computer fails, that's your opportunity to be a hero. So always look out for opportunities to be able to swoop in and help out your trial team for something that may not have anticipated or expected.
Yeah, I want to touch on something that Liz mentioned, which was the motions in limine, because a lot of this dovetails. And so when we're talking about pretrial and doing exhibits, issues relevant to that may be motions in limine. And so you do need to have some coordination on your arguments where you're going to be objecting to exhibits or fighting against motions in limine, that you need to have all of that coordinated.
All right.
Yeah, I'll just throw this out as a tip. It's not really for younger people, but it could be. It's kind of a neat trick that if you have really important exhibit like Liz was alluding to, that you want to determine whether or not it's going to be admitted pretrial, and you're not going to be in federal court where you're going to have any ability to know before you open whether a document is going to be in or out. There's a rule, I think it's Rule 104C in the Rules of Evidence in state court in Texas, that allows you to file a motion for pretrial admissibility, a ruling on a pretrial ruling on admissibility of evidence. And if it's a really important piece that you want to try to get in, or it's something that you perhaps don't want in, there is a mechanism where you can have a hearing before trial where you can get the court to rule on that. And so while the judge may not have the patience to do all of the exhibits in the 30 minutes of pretrial you normally get in state court, you can set a separate hearing on really important exhibits.
One another little tip I think we had talked about before this is, when you're organizing your exhibit list as kind of the most junior attorney, make sure you have the Bates numbers on there as well. And know if there are duplicates in the Bates, what those numbers are. So when you get conflicting exhibit lists as they change on the fly, as you're trying to make agreements, you can be sure that you're not arguing against admissibility of a document that's on your exhibit list.
All right, I'm going to follow up with that too. One of the things I learned in this last trial, which was really great, and I've never done it before, is that there's a program, I guess, that you can use. I don't know if it's Adobe, that will have the Bates number, but it'll have a .001 for each page of a document. And so when so when you're calling it out to whomever's responsible for pulling it up, or the witness, it's easier to reference that number, exhibit 4002, than the Bates number. So that's just a tip. It's a little bit easier.
Never seen that before. Anything else on pretrial?
I guess I'll say, because I had the opportunity in all of my trial experience is really observing, not really having speaking roles. My judge that I clerked for ran his courtroom, even though he was a federal judge, like a state court judge. And so when I saw the exhibit list in the case that we went to trial in, combined almost 2,000 exhibits, I was surprised that Judge Hainan spent so much time, because I know that if my judge had seen that exhibit list, like, we're not gonna do that. We're just gonna do it old school, and you lay the foundation, you get in what you get in. And so I would say, be prepared that if you get a crotchety old judge, they might not want to sit through a 2.5 day pre-trial conference and go through every exhibit.
True.
Well, why don't we move on and talk a little bit about what comes after pretrial? It's going to be voir dire and opening statements. So I think Stephen and I are going to tag team this one. I've never done a voir dire. Stephen, what kind of insights do you have to offer to a young attorney?
I would say that at some point it's going to be your first voir dire. So it'll be nerve wracking. And I think one of the best things that I can remember, and I've tried some cases recently with some young lawyers that I would recommend they do, is if you had the time, I would go watch a voir dire. Sometimes trials are still done by Zoom. You may be able to watch one on TV on your computer in your office, but if you can get out and go watch a voir dire, it's really helpful to see what happens. I would read a transcript if you can get one. Doing one or the other or both helps demystify the process of voir dire because it seems perhaps frightening to think about it, but it's really not that scary once you understand what's going on and you've seen it. So I would think do that. For a young lawyer, I would, if they're not doing the voir dire, they have a very important role, which is to listen and take copious notes. And I know that Miranda has an example of what we did recently. And it's a chart and it's a lot of information to accumulate in a fairly short period of time. And the lawyer, whoever it is, old or young, that's doing the speaking, it's very difficult, for at least for me, to take the notes that you need to take. And so I rely heavily on the young lawyers. And in the case I tried last year with one of our young associates, that was one of her main jobs, was to take notes, because when we go back and have a very little time to figure out who we're going to strike, we're going to rely a lot on everybody's notes. And so the young lawyers are very important, have a very important role in that.
I think that's a great point. And just to piggyback on that, I think as a young attorney, you should never be idle during a trial. I mean, you should always be doing something. Your hands should be moving. You should be paying attention, taking notes, even if it's not your part, so to speak. It's not a time to relax. You know, you need to do everything you can to help the rest of your trial team.
Right. And so the war story I have for that from last year is the young lawyer, Miranda, who was trying the case with me. I picked the jury and she was helping me. And I said, the main thing that she needed to do other than taking notes was, before I sat down, I was going to turn and look at her, and she was going to give me a sticky note with all the numbers of the jurors that had not said anything during voir dire, so that I would at least talk to them. And it's hard when you're doing it to remember who has and hasn't spoken. And so she did that. And one of the things that she did on top of that, which I think reflected her skill, was that she told me to ask those questions and then sit down and shut up, because I've been going on way too long. So don't be afraid to tell your lawyer that's doing the heavy lifting that it may be time for him to shut it down, or her.
One, I think, focusing on body language too is very important, because the attorney that's speaking is focused on what they're saying. They're not necessarily
That's good.
reading the people in the room.
Good point.
So Stephen, I'd heard you talk about this concept of a fear list when doing voir dire.
Yes.
Can you tell us a little bit about that?
So I think it's pretty basic that you need to figure out what type of juror you want the least on your jury. And so come up with the fear list of leanings, biases, prejudices, work histories, just a profile of somebody that would be your worst nightmare. If you're on a plaintiff, for example, you may not want anybody on your jury who's not willing to award a lot of mental anguish damages. If it's an insurance coverage case and you represent the insurance company, you may not want anybody on your jury that's ever had a terrible experience with an insurance company. And so those are the ones that you're trying to tease out. You tease out that, and you're looking for somebody who hates your client, or people like your client, companies like your client, so that you can get them to tease out that prejudice and bias, because that allows you then to ask if anybody else feels the same way that Mr. Smith felt, and it makes it a lot easier. And conversely, what you don't want to do is flag for the other side of the jurors that you love and that you think will be sympathetic to your themes or your case, because that allows them, if they're not doing a good job picking a jury, you don't want to do their work for them.
So what about the flip side of the fear list? What about good jurors? How do you approach that?
Well, again, that's where you need to have some idea of questions that you can ask to elicit some information from them that might confirm that they may be leaning your way, but you don't want to highlight, certainly for the other side, who they are. So that's part of what your work has to be when you're getting ready for jury selection, is to come up with what type of questions can you ask that's going to help you at least elicit from people that don't really want to talk something about their background that you think will help. And it could be that a juror that has a terrible experience with insurance companies, as an example, may also be willing to strongly feel about following contracts and enforcing agreements as they're written, which can be perhaps more beneficial to you and not as it overcome the concern that you have with people that have terrible experiences with clients like yours.
You talked a little bit about jurors that aren't willing to talk, and you told us your story about Amanda giving you the sticky notes. I understand you had a recent experience with a juror who certainly did not talk. Can you tell us a little bit
Yeah.
about that and
Yeah,
your approach?
that's right. And Miranda was there for this. So we had a panel of, I don't know, I think it was 65 jurors. And one of the key issues, of course, during the voir dire was who had any relationship with any of the parties in the case. And one of the defendants was a fairly large local company that everybody would know about. And a lot of time was spent both on the plaintiff and defense side talking about connections with that defendant. And not surprisingly, most of the people, there were some jurors that knew that company and had relationships with the company, and they were excused for cause. And there was one juror that just didn't bother to mention anything. And then she, of course, was selected as a juror and had to inform the court after she had been seated and the panel had been excused that she did in fact have a relationship with this defendant where she would be financially rewarded perhaps, and that she admitted when she was finally asked about it that she couldn't be fair. And so again, I don't know how you elicit so that if somebody knows that they've got a conflict or a bias, but they won't talk about it because they're nervous, is what was her excuse. I really don't know what you can do about that. I've never experienced anything like that, but it does happen.
Why don't we shift gears a little bit and talk about opening statements? For my part, I recently had the chance to do an opening statement in a trial. And so I can tell you quite honestly and with humility, it was terrifying. Kind of my best tip, and I think the best way I was able to manage the fear is practice. You know, it sounds cliche, but practice, and practice again. I spent several hours in front of the hotel bathroom mirror practicing my opening and timing myself. And when I got in front of the jury to do my opening, you know, I still was a little freaked out. And so I can't imagine how bad it would have been without all the practice. So that would be my number one advice. The other thing, which didn't occur to me really until a little bit too late in trial preparations, but I managed to get it done, was aligning your theme of your opening with what the rest of your trial team is going to say. You might be assigned a discrete part of a trial, like an opening or a closing. But you've got to remember that it all is supposed to flow together. You know, you need to identify the same themes in your opening that the rest of your trial team is going to bring up time and time again throughout the rest of the trial. So make sure you're aligned with the rest of your trial team, and make sure you're not disjointed from the rest of the trial presentation.
Yeah, I'll reiterate that you may, as a young lawyer, have a witness. And so it may be easy for you to be narrow, focused, myopic or whatever, and not be seeing the forest because you're so focused on your one witness. But if you're going to get an opportunity to do an opening or even the voir dire or closing, the themes need to be built at the beginning of voir dire, presented again in opening, and then you'll hope you want to be able to come back to them in closing. So you do need to work with the rest of the team to understand what those themes are going to be.
What about a presentation? So, you know, I practiced like I talked earlier, but I still was a little freaked out and I wanted to have my notes in my hand, you know. And they came in handy because one time I got completely off track and I went blank. And so I looked at my notes and got right back into my spiel. You know, I think, and Stephen can weigh in on this, I think you want to avoid reading, you know, from a prepared presentation, obviously, but
Right.
in my opinion, if it makes you feel better, clutching those notes in your hand, you can use them as a prop.
Yeah, I agree.
You can have them with you and get you back on track just to give you a little bit of confidence.
It's what's comfortable to you, and that's one of the overarching themes of today is you got to be you, and so you got to figure out what makes you feel comfortable because you are going to be very nervous. You will always be nervous, but certainly as a young lawyer, you're going to be super nervous. So you need something where you will lose track. It's guaranteed. You're going to lose your place. You will ultimately forget to say something that you really thought was important and wanted to say. So putting that aside, having notes are great. It's just really more of a question of how those notes manifest themselves. It can be in a legal pad, but don't read it. Just have it, as you say, a reference. So it shouldn't be a script. It needs to be an outline probably, but you could also do it with a flip chart where you can write out your key points and it's on the flip chart that you can always look back to figure out where you left off or where you need to go to next. And then, of course, you can use a PowerPoint presentation if it's suitable for that case, where you can have your outline. The jury, I think judges will tell you this. A lot of judges will tell you this. They don't want a lot of PowerPoints. The jury doesn't like to read the PowerPoints, and you don't want them focusing on your PowerPoints. You want them looking at you while you're talking to them. But it depending on the technology and all, that may be another way to do it, where you won't lose your train of thought if you've got slides and you know what the next slide is, and it'll give you the next topic to talk about. So it's whatever you're comfortable doing.
To that point on flip charts, one thing I noticed from my first trial was that the senior attorney used a flip chart in his opening statement and wrote out the key things on the flip chart. And that flip chart ended up just staying there in the corner by the jury box the whole trial. I think the plaintiff's counsel forgot it was there. So our key themes were written up there and pointed right at the jury the whole time. So just a sneaky tactic.
And then you
to
can
consider.
then you can use the same outline in closing if it's still there.
And if you're the junior associate working with the senior partner on the other side, that's a good time to do a sharp elbow and say, hey, that's still over there. You might want to ask the judge to remove that.
Flip the page.
Yes.
Another thing I think, and we talked a little bit about aligning your opening with the rest of the case. What about promises you make in an opening?
Yeah, be careful, right? Don't make a promise that you don't think you can fulfill. And so this part of this goes back to the pretrial exercise. In state courts, you may not be able to know what exhibits or evidence is going to be guaranteed to come in, because you're not going to get a pretrial hearing like you would in federal court. But even in our last experience that Miranda lived through, because of the 2,000 exhibits, the 2 days pretrial, we couldn't get them all ruled on. And the judge admonished us that said, look, I'm sorry, I just can't get through them all. It's your fault because you've got so many dang exhibits. So be careful putting too many things in your PowerPoint presentations, because it may not come in. And so then you have to make the educated decision on whether you think, it's a lock to come in. But more generally speaking, you need to be careful of what you promise, and just generally what you think that the evidence is going to show the jury, because if you don't get that evidence in, you're going to hear from it from the other side. And so therefore the flip of that, which is something that's helpful for the young lawyers, again, they need to be working and they need to keep taking notes of what the other side is promising in their opening, and then keeping track and helping the senior lawyer, whoever's closing, recognize where there's gaps. And if something didn't come in that they promised, you want to pound them, the other side, in closing about that.
All right.
Nothing makes you look smarter than on the fly throwing out somebody else's words. So if you've written down a phrase that they repeated or something like that, that you can pass across at a key moment, you can either improve your credibility or hit theirs.
Yeah, and one final thing I'd like to say for the young lawyers is have fun. This is opening. You're gonna know what you're gonna say. It's rare that the other side's gonna object. So once you've got it down, you know what you're gonna be saying. And so have fun and be a little loose. Don't be frozen behind a podium. Don't climb in the jury box, and most judges will not let you do that, but you don't want to get too close and invade the jury's space. But move around, communicate with them, try to make a connection, eye contact, and try to get some vibes from it and read the jury. But enjoy it. I know you're nervous, but it actually is more like acting. It's fun.
Mm-hmm.
So we've survived opening statements, nobody's passed out, and the plaintiff is putting on their first witness. So let's switch gears and talk a little bit about that. So we're gonna talk about this from the perspective of being a defense counsel. So the plaintiff has put on their witness, and as a young attorney, you might have been assigned the cross-examination of that witness. But you can't forget, and this is something that I forgot the first time I put on a witness or cross-examined a witness, is you've got to be ready to object when they're on direct. So my advice is anticipate as much of that as possible beforehand. You may not be slick, you may not be an experienced attorney yet, but you can mitigate that by preparing. Be familiar with your motions in limine. Have an understanding of what the objections you're likely to make are going to be. One thing that happened to me was an improper use of a deposition that the plaintiff's counsel was trying to do. The witness was not saying what the plaintiff counsel wanted them to say, and so they whipped out a deposition and just started reading it. And to be honest, I wasn't quite sure what the proper objection was, but I felt that something was off about that. You can't just do that. That doesn't seem fair. So I just stood up and objected and figured out the rest of it later. And, you know, the judge, who was maybe not paying super close attention, was alert and realized what was happening and kind of figured out the rationale for the objection for me, and stopped the plaintiff's counsel from doing that. So that's my advice. You know, you always remember that it's not so simple. It's just your assignment of cross-examining the
Yeah.
witness. You know, you have to be alert the whole time, be ready to object.
You're right, and I think it's easy, and it happens to me as well, that when the witness gets on and it's a slow start, the other side's got the witness on and they're doing background, and it's easy for my mind to go to my outline for my cross while this sort of unimportant testimony is happening. You do need to stay engaged and not think about your cross outline, because you're going to need to be on your toes and object. I would suggest that you don't have to object just because you can. You're going to irritate the jury, and not every objectionable question is one that needs to be objected to. So you need to be selective in how you object and when you object. If it's obviously leading or clearly speculation, you know, if you don't really know where they're going, maybe you want to object. You can do it strategically. It may throw the witness off, and you can often throw the lawyer off if you object, and if you think they're on a roll and they've got a tempo with the witness, then you may look for an opportunity to object, just to try to throw them off the track a little bit.
And back to Ryan's point, I think impeachment and a couple more of those rules are good things to just kind of refresh the night before. Everybody does impeachment wrong, I'm pretty sure.
Yeah.
So just take another look at that, maybe hearsay, you know.
Right.
So it's your turn to cross-examine the witness and play the role of the trial room lawyer. And so you get up there and the spotlight's on you. But things are a little bit different than they are, maybe they have been in a deposition or something you've done before. In my first trial, I was dealing with a very difficult witness. And the witness simply wouldn't answer the questions. And at that point, I knew enough to object politely, that it was a non-responsive answer. But the one thing I failed to do was to seek a ruling on that objection. I treated it like a deposition, said objection non-responsive, and asked the question again. So my advice would be, don't make the same mistake. You know, ask the judge to rule on your objection. They may not automatically do it for you. Another piece of advice for mine is, if a witness simply won't admit a fact, or that a document says a fact, having them admit that the document says what it says is almost the same thing as getting them to admit that what is on that document is in fact a fact. So you don't have to wrestle with them forever to try to get them to say exactly what you want them to say. Sometimes having them admit that the document says that is enough. Another advice from me is just to be yourself. And I know we've talked about this a lot. In my particular case, the witness was a little bit mean, to be honest. And you know, I try not to stoop down to the witness's level if they sense you're a young attorney and they want to try to overpower you. You know, be polite, be honest, be frank and forthright. And I think the jury appreciated that when I did that in my case.
I think it's a rule that should apply to every lawyer, but it certainly applies to a younger lawyer, which is, don't ask a question that you don't know the answer to. And if you have the luxury of having a case where you've deposed the witnesses that you're going to be cross-examining, there really shouldn't be many questions on your outline that you don't know the answer to, because you have the email, or the document, or the deposition testimony that you can use to impeach them with. And so get back to Liz's point. You're right. You need to know the rules for impeachment. They're slightly different, federal court and state court, depends on if it's a party or not in federal court, but know how to do it correctly, and be sure that you're prepared pre-trial to have your kit for the witness, if it's your witness, that you have extra copies of depositions so they can have one on the witness stand and you don't have to keep walking back and forth. And if you know there's a really one or more key admissions in a deposition, for example, that you have the benefit of videotaping, you would love to have those clips cut before trial so that when the witness starts to squirm like you expected them to, you can lay the predicate and then tell your staff to just hit play on clip 4 and the jury can watch the witness answer the question the way you knew they were going to answer the question in their depo. And that can be very powerful. So definitely know how to impeach correctly. But certainly be careful not going off script. But again, it sounds maybe sounds like I'm contradicting myself. You want to have your outline and know the answers and have the citations and be prepared to impeach, but you need to listen to your witness because there will be moments, it seems like in every trial, where that witness will say something that you're not expecting them to say. And don't go to the next question in your outline because you may need to go down that rabbit trail and they may say something that is meaningful in the case that can help you. It happened in the trial we had last month. And so you just have to be active listening to the witness, even though you have your outline. Be prepared to go down. They may fumble, they may say something in the wrong way, and it may be an opportunity for you to pounce.
And I think as a young attorney, I found particularly, it's okay to take a breath. You might want to just start down your outline with a witness, but Stephen's right, you need to listen. And if you hear something that, sets a neuron on fire, take a breath before you react to it.
Right. And I like to encourage myself and the young lawyers to have 2 or 3 questions in the can, as I call it the dismount. Sort of have a natural stopping point as opposed to just running to the end of your outline. So think about what you have. And it may be questions that you've already asked and you're summarizing the key points of your cross, but have a dismount where you've got 2 or 3 questions where you can get them to, isn't it true this, isn't it true that, and then pass the witness. And, you can perhaps be emotional with it if you really make a good point. You can drop your pen or look at the jury or whatever, but it's better than just sort of this fade out where you get to the end of your outline. Let's have something a little bit more dramatic.
I think that's great advice. And my advice would be to go with your analogy, don't fumble those last questions. Fight for the answers that you want with those last questions. You're worn down, the witness is worn down. You just want to get out of there, but make sure you get the answers to those questions that you deserve and that you know are right before you finish your cross and pass the witness.
When in psychology, they talk about the primacy and the recency effect. Your fact finder is going to remember the very first thing and the very last thing more than the messy middle.
And for the young person, if you're not doing the cross, you got to be active. You got to be taking notes, and don't be afraid to pass a note if you think that there was a question that the lawyer missed, or maybe he didn't hear the answer. Before they pass the witness, you want to be sure that you've had an opportunity to tell your lawyer to think about maybe asking another question before it lets the witness go.
What about experts? How do we handle plaintiffs' experts, and what's an advice for a young attorney?
A lot of it's the same, that you should have an outline. If you've had the benefit of a deposition, maybe in your case, or prior deposition testimony. If it's an expert that's testified a lot, don't ask them questions that you don't already know the answer to if you can avoid it. But I would also think that there's an opportunity, often in state court, to take another shot at striking an expert. If you try to pretrial, often, my experience is that trial judges in state court often don't have the time or interest in having a full-blown Delbert hearing before trial, and they'll often say, we'll do it at pretrial, which didn't seem to happen, or it may happen during trial, or maybe you don't get the judge's attention pretrial and that you don't win your motion to strike. Don't give up, and you need to do it again at trial. And the recent experience I had with a young lawyer with Miranda last year was we'd lost the motion to strike one of the plaintiff's main experts pre-trial, and before the plaintiff put that witness on, Amanda asked the judge if she could put the witness on voir dire outside the presence of the jury. And she spent about 10 or 15 minutes cross-examining this expert and moved to strike him because he wasn't qualified, and it was Ipsy Dixit, and it was a mess. And the judge granted it, surprisingly, frankly. And so you can imagine the impact that had on the other side's case. But even if you don't win the motion, the fact that you've taken the witness through voir dire, and this may even be beneficial if you hadn't taken their deposition, but you have an opportunity to basically cross-examine them out of the presence of the jury. And if you don't win the motion, you still have your first 5 minutes of your cross that you've just really had a dry run through, that you would use those same questions when you tee them up in front of the jury, so they can hear you grill them on his or her lack of qualifications.
And you get some preview of what they're gonna say in case any opinions have changed. I think, my biggest advice is the most basic advice. Know the report inside and out, know the deposition inside and out, have in your outline, cross-reference everything 12 ways to Sunday, because you're gonna remember something and you're gonna need it in your fingers. And it's best to have it in the outline, have your cheat sheet of kind of the big things you want to be able to impeach them with.
And I think a young lawyer can often think they need to accomplish too much with an expert, and you don't necessarily win your case trying to cross-examine the other side's expert. So don't try to bite off more than you really can. Know what you can get from the prior testimony and get in and get out.
And it's a credibility battle, I think, more than it is, you're not gonna get anything out of them
Right.
that helps you. You're just gonna keep them from putting in something that hurts you.
Right.
So why don't we move on? So plaintiff's case is finished and it's your turn. You've got a friendly witness up there and you're doing your first direct examination. I had the chance to do this recently. My advice is practice, practice, practice. It's the same advice I had for the cross-examination and the opening. But one important thing is don't script it, because it'll come off that way.
Right.
So make sure you spend some time with the witness, go through whatever documents you want to use. Consider how you're going to get those documents in as evidence if you need them. And make it a conversation, let the witness tell you what they want you to tell, or what you want them to tell you. Don't ask them and lead them along in a blunt manner.
Yeah, I think if you have the time where you can spend time with your witness, you need to do it. You need to practice, and don't script it, but you want to go over the outline with your witness enough so they at least have a general idea where you're going. And that, to me, that's your job on direct, is to be sort of the traffic cop. And you're letting the witness tell the story, because inevitably, if they're a fact witness, they've lived this. And so they should remember it, and just what comes out and in what order is up to you. And when it appears that the witness needs to prompt, then you ask the next question, but you get to drive them. And so you need to make sure that you're fully prepared with your kits and your exhibits and your notebook to know, where you want to go next with the witness sort of dies out. So, that's mainly your job, is not to ask a bunch of leading questions, because you can't do that. And the jury don't want to hear from you. They want to hear from your witness. So just help them move along through the chronology, or however you want to do it.
So your direct is done, and we're moving on to the plaintiff crossing your witness. What are some of the things that, or excuse me, you're cross-examining no, plaintiff is crossing your witness. I'm
We're
sorry.
defending
Yeah.
the cross.
What about objecting? How much is too much when objecting, Stephen?
Again, you have to feel it. You got to read the room. If your witness is floundering, then that's probably a good time, if you can, to get up and object, just to sort of change everything, give them a break. You hope you don't have to object much, because it looks like you're trying to save your witness from getting pounded by the other side, and I think the jury would perceive it. So if the other lawyer is asking just unfair questions, and we had a lot of that in this last trial, where it seemed like the question would take 5 minutes to come out of the lawyer's mouth, and he's asked 5 different things in a very argumentative way, and then the question to the witness would be, "You were here for that, right?" And so it's an innocuous question where the lawyer has argued a point. And that's the kind of stuff that you should object to. If it's obviously asking for an expert opinion, maybe from a fact witness, you would want to raise that so that they're not taking unfair advantage of your witness. But I think you got to hope that you've prepared them well, and that they're going to be able to handle it. But you need to be prepared to bail them out if they're really getting beat up.
And, like you said, you'll be objecting when the plaintiff is taking your witness, right? And it's hard to object and take notes at the same time.
Right.
So I think one great thing to do, if you're in that supporting role as a young attorney, is take notes for things you need to clean up on redirects.
Right.
Because the attorney who's protecting the witness, may not have time or the ability to keep track of all those things.
And you're right, because you may, as the lawyer whose witness it is that's being crossed, your mind may go somewhere and you may miss a finer point that the rest of your team, the younger lawyer, may have picked up on. So don't be afraid to write down that note and make sure that whoever's witness it is, that lawyer's conscious of what you've seen so that they don't miss it. That's important. I would say if as a younger lawyer, if this is going to be your witness that you're going to be defending, you should hearsay, speculation, and opinions. If they're asking a fact witness, a lay person, an opinion, those are the three things that I would look for and object. If they want to try to get in hearsay through your witness, object. And if they're asking to speculate about some email that he hadn't written or she hadn't written, yeah, I would object to that as well. So there are some times when it's pretty obvious that you want to, but I would not do it unless you really need to. And make sure that the opposing counsel is impeaching your witness properly. So that they often don't know how to do it correctly either, or they're trying to impeach the witness when they're impeaching him with the same answer that they gave in a deposition, and it's not really proper because
When,
don't be shy about raising that.
cross is limited to what was raised on direct too, is another kind of area. to pick.
State or federal court, right?
So let's move on to jury charge and closing. The parties have rested, and now you may have been whisked into a back room somewhere to negotiate with opposing counsel on the jury charge, if it hasn't been finalized yet. I recently had the opportunity to do this, and one of my biggest pieces of advice is to come prepared. The opposing counsel did not have the latest pattern jury charge. And for every question they want, it was pretty easy to demonstrate, no, this is actually kind of the pattern jury charge. Do you really want to argue this in front of the judge? So I think we should go from here. Understand what questions they're going to want and why they shouldn't be able to have it. And on the same side, or on the flip side, understand what questions you want and exactly why those are the right questions to have. And be able to articulate that ahead of time, so you're not scrambling when you're negotiating the final jury charge.
Yeah, when it comes to charge time, as a young lawyer, there's sort of an art to it in preserving error, which is one of the main parts of jury selection that's very important, is preserving error for appeal. And if there's an appellate person in the firm that in the case justifies it, then you clearly want to loop them in, pre-trial, but have them there for the charge conference. Inevitably, there'll be an informal charge conference where you're going to be talking to the judge about the charge before the formal charge conference. So, you sort of have two bites at the apple, but you need to understand the basic ground rules of if it's their burden of proof, you don't need to tender the question. You just need to object to it. If it's your burden of proof, you better have a properly framed question that you will hand to the judge and have him or her sign it, sustaining some objection or making a record that it was tendered and it was refused by the court. So you just need to appreciate those sort of ground rules on how you preserve error by either objecting or tendering a properly worded instruction or question. And as you pointed out, I think if you can find your question or instruction in the pattern jury charge, 90% of the time you're going to get it from the judge. If it's a more complicated case and it's not there, you just got to be armed with a bunch of cases that support it. But you just need to make sure that you've got something typed up, ready to submit. So one of the things I've done, and it's been helpful to me, is I have a discussion version, which is the entire charge with the other side's questions and instructions and my questions and instructions, if any, that we can hand to the judge and walk them through and say, this is what it's supposed to look like. This is why I think their questions are wrong. And then when the judge disagrees with half of what you want, then you've got your tender set ready to go, and that you can go through them one at a time and get the judge to rule on them and sign them when he or she doesn't use them. So being prepared is the main thing, because there are a lot of fur flying and there's a lot going on and it happens in a very short period of time. And if you hadn't thought about it beforehand, inevitably you're going to drop the ball on something.
So what about after the jury charge? It's time for closing arguments. So I have never done a closing argument. Miranda, I don't think you have either. Liz, have you?
I don't think so, but
Okay.
It
Well,
wasn't memorable.
yeah, I did an administrative hearing years ago and we kind of waived a lot of particulars,
Well,
so.
luckily we have Stephen here, who recently tried a case with the young associate who couldn't join us today. But I think he can relate secondhand some of his impressions of her first closing argument and some advice she might give her.
And it was good. She, it's back to opening. You don't get as much time to practice, but you've just lived through the case for 1, 2, 3 days, maybe longer. So it's all fresh. So you want to build on the same themes. To your point, if you'd had a flip chart that somebody used in opening, you'd like to use as much of that as you can in closing, because you want to, again, embrace the same themes. I would say you're going to maybe want a demonstrative of some sort, some key document. If it's a chronology, maybe it's a document that you've used during trial with a witness. And inevitably, you're going to need the charge in some form to walk the jury through. And it can be, last trial, we had them pre-prepared in PowerPoints where we were telling the jury how to answer the question. You could have them blown up on a foam board if you want, or you can maybe just have it in your hand, but you need to walk the jury through the charge and, make sure you've got the answers with you. So you'll forget some things like opening. And so you want to have an outline of some sort. You want to, again, move around the courtroom and communicate with the jury. Again, you want to enjoy it and have fun with it. And I just think having something to ground you, which is an outline, which part of it will be the jury charge, but if you've got a demonstrative or something that'll help you, or flip chart that help you walk through, you won't get lost.
I think once again, and this has been another overarching theme, is just be yourself. You don't need to be the lawyer on TV giving an absolutely devastating closing argument. I think be yourself, have fun, be natural, and I think the jury will better listen to what you have to say and probably like you a little bit more, consider you more genuine than if you're acting and trying to be someone you're not.
Right.
And bring it back to, in the beginning with Vordar and with opening, you're making a promise. This is your chance to say, I told you this is what I was gonna show you and I did. You can trust me and I'm telling you.
Right, those are the things that you want to focus on in your closing, are the things that you promised and delivered on, and how that fits in with the answers to the charge.
And one thing I think, as someone who watched closings in the trial we were in, one thing that I thought we did better than the other side was just giving exhibit numbers and saying, this is what we think is important. Go think about it with yourself, rather than think about it and reach your conclusion, rather than mischaracterizing it and just, saying this is what this exhibit says, and then just throwing things up and talking about it and putting them down, as opposed to directing them to the key points.
That was very important,
Mhm.
because the jury deliberated for a couple of days, and they sent out a lot of notes asking about specific exhibit numbers, and they were taking notes during trial. But the fact that we were anchoring them to specific exhibits that were proving key points, the evidence was in those documents, I think helped a lot, because the jury was able to go find those.
So I think that brings us to the end of our discussion. We set aside a little bit of time for Q&A. I'm not sure if our audience's microphones will work, but feel free to throw a question down in the chat, and we can discuss and answer. In the meantime here, I'd like to introduce our next upcoming CLE. This is a great one. I've seen it personally. It's called ChatGPT Didn't Write the CLE, or did it? This is by Colin Watterson. He's on the cutting edge of AI. He's familiar with all the latest cases, and it's a really fun presentation.
And he's a real person.
He is a real person. This will be on March 26, 2024. So we'll hang around a little bit, and if anybody has any questions, please go ahead and throw them down in the meeting chat, and we can come back online and discuss. But other than that, thank you so much for joining us. Oh, the CLE number. I've been reminded to give you the CLE number. We'll go ahead and leave this up. There we go. Yeah, someone asked about the CLE number. We'll leave this up. You get 1 accredited hours, unfortunately, no ethics hours. But once again, we hope you enjoyed our presentation. We try to approach it with humility and a little bit of humor. So yeah, thank you again. And until next time, thanks for joining the Hicks Thomas monthly CLE.